Hi, good morning. This is Whitney Phillips. So today on the agenda, we have a number of items. First of all, legislative updates that I'll be going over, regulatory updates, school safety and privacy, record officer resources that some data managers may be interested in, and online education and privacy questions and answers. We are going to be keeping the chat function on, and Greg will be keeping track of all of the questions within the chat, and we'll be answering those at the end. So please, again, everyone stay muted and your video off so we can keep the quality of this call top level. Feel free to ask questions. We want to hear what you have to say. We've been getting a lot of questions during this time, and I know there's a lot on your mind. Know that if you ask a question, Greg will keep track of it, and we will address the question at the end. So now to get started, again, I'm talking about legislative updates. There were a record number of bills passed this last legislative session, and we wanted to focus on really three that may have some type of privacy-related concern. And so the first one we want to talk about is HB 171. I don't know if you're familiar with this, but it creates a crime if there is a threat, whether it's real or just a hoax, if there is a threat against a school, and it provides a misdemeanor and other penalties for threats. And I'm going to give you a little more detail about this, but essentially in January of just this year, and at other times as well, there have been reported threats. For example, in this article, it was Jordan High School that someone reported that they saw something written on a bathroom wall saying that the school was going to be bombed. This triggered Canyon School District protocols, and the building was quickly evacuated, and 2,000 students were outside and away from the building for nearly 2 hours in very cold conditions. 2 hours later, the police sounded the all clear, and students were allowed back into the building. And this was a hoax. And when the school looked into their options on how to prosecute, they discovered that there isn't a law that prohibits hoaxing and causing threats to schools, whether it be real or not. And so Representative Stoddard, he drafted this bill, and it was passed, HB 171. And it says that it makes these particular threats misdemeanors. And you can see the different classes there. So the question we have is, what is a threat? In the bill, it says threats are made in person or electronically to commit any offense involving bodily injury, death, or substantial property damage, and one of the following occur. There's a use of a firearm. The act is to disrupt regular school schedule. The act intends to prevent the occupancy of a school or portion of the school. The act has the intent to intimidate or coerce students or employees, and it causes an official or volunteer to take action. One of our questions that we have is, what is taking action? Is that making a phone call? Is that going down the hall and looking at some threat? Is it what does that mean? So we're not entirely sure, but taking action, it's something that they need to do. So what does this mean? What does this have to do with privacy? Well, as we know, FERPA relates to education records, which are directly related to the student and maintained by the school. And parents have certain rights to these records. They have the right to access them, as do the students. And so what is this record? Is this an education record? Now, what we're suggesting is that schools shall, when they report these violations, and in the bill, it actually says that they shall report these violations, these threats to law enforcement, that they designate these records, they designate them as law enforcement unit records. Now, this terminology is a little new for some folks, and David is going to talk about school safety and privacy later on, so I don't want to get too much in the weeds, but essentially, schools can designate a law enforcement unit. It sounds like a really tough term, but that law enforcement unit can be an SRO, a school resource officer, or it can be a vice principal or a counselor or the principal. You just need to designate someone or some group as the law enforcement unit. Records created by that law enforcement unit are law enforcement unit records, and they should be stored separately than the education records. These law enforcement units are used, or law enforcement records are used for investigations, anything related to an investigation by a local law enforcement unit, or just the typical police department. And so you should keep them separate. And now some of the information can be the same. If there was a hoax, you may have a law enforcement unit record that has to do with pursuing the criminal investigation. And then you may have information on the hoax that is in education records that has to do with school discipline. That's not for any kind of criminal pursuit into going through the court system. It is just through the LEA system. So the records may look the same. Parents have access to the education records. They do not have access to a law enforcement unit record. David will go into that in more detail. Okay, the next bill I wanted to talk about from this legislative session is HB 323. There was a lot of conversation about this that we saw, and this is a mental health funding, and it's for a mental health screener. So we're all pretty familiar with a screener for vision or hearing in schools. It's just to see if a student has a flag of whether they can see or not. For example, I took my son to, I got a result that my son could not see a 20/20 vision, which I didn't know of. They didn't give me a prescription, but they gave me a flag that said, hey, you might want to look into this. And so I did, and now he wears glasses. So it's just a screener to say, you know, you might want to look into a particular issue. And this just happens to be for mental health. Now, this is just funding for a mental health screener. So LEAs may, they do not need to, implement a mental health screening in a program approved by USBE. I don't believe that USBE has a list quite yet of those screeners. Now, with this written in the bill, they need to obtain parental consent prior to administering the screener. The results of the screener will be sent to the Department of Mental Health and Substance Abuse, and this will be only with parental consent. The results, if there is any kind of potential mental health condition, just like a vision condition or a hearing conditions, the LEA shall notify the parents and provide them the results and also some resources and services. USBE may distribute funds to LEAs to use to assist parents to pay for these services. So this was passed, but one of the privacy considerations that we really want you to focus on is that consent form. So we need to make sure that the parental consent form is compliant with what we call Utah FERPA. And Utah FERPA requires that the consent be signed 2 weeks or more before an administration of a survey or a screener like this. The bill goes on to clarify that information collected by this screener, by anything in Utah FERPA, actually cannot be a part of the student achievement backpack. And the student achievement backpack typically gets passed on from one district to another, and parents have access to that. Now, they would still be education records because they're directly related to the student and maintained by the school. This might be the screener's outcome itself rather than the screener specifically. For example, all of the questions in the actual photocopy of the screener might not be kept, but the flag that indicates whether a student may or may not have a mental health condition may be a part of an education record if it is maintained by the school. This means that it can still be accessed by parents. And what's important here and what schools will need to consider is this last point here. Since they would be an education record, schools would need to determine which school officials have a legitimate educational interest in accessing these results. Because this is very sensitive information, you're at the local level will need to determine who needs to have this information in order to provide that legitimate educational services to that student. Now, this is changes to student data privacy amendments. This was very exciting. This was exciting because this passed at 11:45 p.m. the last night of the legislative session. So I know you were all up. You all had, your phones on, trying to see what's going on, keeping track of it. I'm kidding. But this was very exciting for us because we recommended a few changes to the Student Data Protection Act, and Senator Anderegg was very willing to go to bat for us and make these changes. So here are some of the changes that we made. They're fairly minor, but we think you're going to like them and want to be aware of them. Now, in the Student Data Protection Act, it wanted this data collection notice to be a standalone document. And so many LEAs were creating the data governance plan and PPRA policies and their FERPA notices. And then they had at a separate location, this standalone student data collection notice. And I think the original intent was that notice would be standalone and it would be prominent. It would be standalone, so it wouldn't be kind of in the weeds with others. But what we found was it was getting lost because it wasn't with these other documents. And so this clarifies that the federal and state required privacy notices can be combined. And we feel like this was also very parent friendly. I know registering my students, it's really nice when you have that information all in one place and not disparate across different areas. So we're hoping that this provides for more flexibility. It doesn't mean that that information has to be all together, but it's now up to you. Now, the other issue we ran into is we have these contracting requirements when entering into agreements when LEAs disclose any student PII, and this is Jessica Callan's position that she works on with the Utah DPA, the Data Privacy Agreement. And there's specific requirements that are required by education entities, which includes USBE and LEAs. Now, what was a little unclear was what is UETN or UEN? And UEN is not an education entity, but they're also not really a third party. And so we wanted to make it clear that if a different organization, for example, UEN or a different government agency is contracting on behalf of LEAs, that they need to follow the same provisions. To be clear, and to their credit, UEN voluntarily were following these provisions because we asked them to include them in their agreements. But this codifies that requirement and makes us feel a little more comfortable. Now, the other issue that we decided to include was that online services that were only receiving directory information did not need to follow these really more restrictive contract provisions. For example, if you're signing students up and only using what's considered directory information as determined by your local policy, such as maybe name, email, and you're providing that information, you do not need to enter into an agreement for that. Now, there's a slight caveat that directory information has that opt-out provision, and so making sure that you know which students have opted out of that is important. And now for the last item, this is something that we tried to get changed last year, but we're not successful in doing, but we have this year. You might not be aware, and we weren't aware either, that that LEAs are required to put student expulsions and suspensions on a student's transcript. At least they were. Now, I don't believe that many, or maybe any, LEAs were following this. And this was done in the early 1990s. It was because the transcript would transfer from student to student, and they wanted to ensure that the new schools knew that that student had been suspended and expelled, especially a school within the same district. And they didn't have these very fancy LMS systems and these SIS systems that we have now. And so that was a way to transfer this information. The problem we had was, if this is required and some of the LEAs may be following this, that information on suspension and expulsion may travel with that student when they apply for college, and that might not be the appropriate place for it to be located. So those were the major changes. We were very excited that this got passed at 11:45 p.m. the last night of legislative session, and I think that this is going to really improve what the work that you're doing. If you have any questions on this, again, put them in the chat. You can email us later. I know it's a lot of information all at once, and we will get to that. We're now going to I'll be handing this off to David Saleh, who will talk about regulatory updates. David?
Thank you, Whitney. So, regulatory updates. These were actually from last fall. So we had our conference last year in person that many of you will remember, and we talked about these before. I want to talk in a little more detail about some applications with them and what they mean. So specifically, I'm going to talk about changes related to the Metadata Dictionary and requirements and audit requirements. And again, I previewed these at our last conference, have some more detail right now to say about both. So first, the Metadata Dictionary. The rule basically says you don't have to use the tool that we have in Data Gateway. You can use any tool that achieves the following. It defines and discloses the personally identifiable student data that you collect and share. It lists recipients who will receive the data, including the purpose for them receiving it, the justification under whether it's justified under federal law. There's a federal requirement, that's why you're sharing it, whether you're sharing it because of state law or it was just a local decision, and how it's permitted under federal or state law, which will generally mean what FERPA rationale or exception you're using. So basically anything that shares all that information you can use for your metadata dictionary. So let's talk about a couple of the options and the problems that we currently have. So one is our Data Gateway tool. Many of you are aware that this tool has been broken since about 2 years now. It's been broken. And the current COVID-19 pandemic is not helping it get fixed anytime soon. I'm hopeful, though, that we're very close to getting it up and running again, as well as having some new features that should enhance its usability. but this likely won't be available until sometime this summer at the soonest. So because of that, you won't be able to use this tool for your metadata dictionary. You cannot enter anything in. If you go in right now, it will seem like you can, but it won't save it. You'll get an error message whenever you hit save, essentially. So I'd recommend staying away from that for the time being. One that we've talked about, and it does get us a little excited, is the Utah Student Privacy Alliance's website. So for those of you who have worked with Jessica and been onboarded, you know that this is a place where you can essentially create a registry of here's the online vendors that have signed DPAs that you're sharing data with. There's that column on the far right where you can hover over and see the data being shared. As currently constructed, though, it doesn't meet all of the requirements for the metadata dictionary I just said. So you can see the data elements, but they're not defined anywhere. It, for the most part, is only being used for online disclosures. There's others that are, you could get in there, but it's not necessarily, we'd have to create some new agreement types, for example, to make it clear that, you know, this is a community partner, this is a researcher, those sorts of things. And there's also no clear way for it to describe the purpose, why is the data being shared, the justification, the FERPA exception. We're hoping to be able to build this out so that it actually does meet all the requirements without you having to, you know, like fit, let's say a square peg into a circle. It's nearly there, but we need to fix it up for it to truly meet all that functionality. So what does this mean? Because the rule also says for October 1, we're supposed to check the metadata dictionary. And I'm telling you right now, we have no good options for you to do the metadata dictionary. Well, I guess I should say there's other options. I forgot about this slide. Other options may exist. I know many are using Learn Platform, which is another thing that could be used. Again, I don't think it would meet all the requirements I just said. Homegrown options that you maybe create yourself, we'd have to review these. But basically, because we do not currently have an option for you this April, our plan is to not check your compliance with this requirement for October 1. As options come online, so when our data gateway tool is available, when the Student Data Privacy Consortium's website has all of the functionality in, we'll provide training and help you get up to speed with it. But we just think it would be unfair to expect you to have that all up and going on October 1 when we're not even sure what it's going to look like. So we're going to give you, again, a little bit of a pass, but once those tools are up and available, we will start helping you get the information in that needs to be there. So the other one, we've already talked a little, Whitney did at least, about these contract requirements. So basically, anytime that an LEA is, in your case, so you are contracting with an ed tech vendor, there's certain requirements that need to appear in that contract. And the easiest way to do this is to use the data privacy agreement, the DPA, and get the vendor to sign off into that. Now, a point we do want to emphasize is just because a student is using a website, it does not necessarily mean that a DPA always has to be used. For example, you might not be sharing any student PII off of an education record. If no PII is being shared, then it doesn't meet the requirement. There's also this idea in the law called a general audience website, so one that is not specifically targeting K through 12. If it is general audience, and a good example are ones that frequently come up with like CTE. Ones like the food handlers permit is a good example where they say, yes, we give certifications out. We're not specifically targeting education. We will not let you have these audit provisions before, you know, we give a kid a certification. Furthermore, like the contract provisions talk about the LEA being able to delete things. So you could request of your vendor to delete. And And that's probably not appropriate if it's a certification, because the student would probably be pretty upset if you had the vendor erase their food handler's permit. There's other cases, as Whitney said, if only directory information is disclosed, then that's another case where you would not need a DPA, or if parental consent is given. Now, that is to say, if those conditions are met, you still have to follow FERPA. So if it's a school official and it's a general audience website, you would still have to maintain direct control over the use and maintenance of any information from education records, and they can't redisclose it. If they're willing to sign a DPA, that's great, because the DPA would meet all those requirements. We're simply saying that it wouldn't necessarily always be required, particularly because there's some requirements, and the main one I'm pointing at is this audit requirement, which is in the DPA. The law says that if the contracting has to have the requirement, you have to have a provision in there that says that either you, the LEA, or a designee can audit compliance with the privacy terms of the contract. And we clarified in board rule last year that this can be more than just what you might immediately think of with an audit. That in a lot of cases, it might be a vendor self-assessment. That one gives you some level of assurance, not necessarily a lot, because you're kind of taking the vendor's word for it. You could send them a questionnaire that's a little more specific, where it's like, hey, can you specifically tell us these things? There are several different industry recognized third-party audits that could be in there. And then the last one would be the most invasive, some sort of on-site audit. So we shared this with you last year, that this is what the board rules said, and we want to explain a little bit more some options you might have, particularly regarding those first two, vendor self-assessment, response to a questionnaire. So if the vendor is self-assessing and publicly posting the results of that self-assessment, and one example of this is something called the Student Privacy Pledge, because we've gotten asked this. The specific example, I don't remember who the vendor was, but the LEA came to us and said they won't sign it, they won't sign the DPA, but they say we follow all these other privacy things. We have the Student Privacy Pledge. We have a COPPA safe harbor. Is that good enough? Are we allowed to take that? And it's like, well, let's see. Like, I mean, are you designating them to do their own self-assessment? Because that's what the Student Privacy Pledge is. They look and they say, yeah, we believe we meet all these requirements. And it has a little bit more teeth than them just publicly posting and saying, this is what we're going to do. It is enforceable by the FTC, because if they say they're meeting these requirements and they're not, that's considered a deceptive trade practice, which violates the FTC Act. And the FTC can then issue, in some cases, really quite large fines, depending on the scale of it. So I'm not saying that you necessarily want to just go through the list of people who have signed the Student Privacy Pledge and say, good enough. I'm actually still very much recommending do the DPA first, make them do the work. But certainly for those situations where it's like, hey, they seem to be doing a lot of good privacy stuff. Is this okay? Does this still meet the requirement? I believe an LEA would be fully within their rights to say, you know what, we are designating them under board rule as providing their own audit. It's the Student Privacy Pledge and good enough. The other one, and I already kind of alluded to it, is this idea of third-party assessments. A lot might be under what's called a COPPA safe harbor. So the Children's Online Privacy Protection Act, or COPPA, relates to certain provisions that companies need to follow in order to collect information from children 13 and younger. And this is administered by the FTC. And under it, they have designated certain companies as safe harbors, where essentially these are kind of like third-party auditors, where they go in and they I think usually annually will review the company. The company pays this safe harbor for the privilege, incidentally. They review that they are meeting all of these different privacy and security requirements. And if they meet that requirement, then they get to put a little badge on their website. There are, I'm trying to remember, seven COPPA safe harbors. You can see all of their names here. I know a lot, particularly with a lot of the stuff you're going to see with education. iKeepSafe is a big one. You might see Privo or Trusty. ESRB, that generally has to do more with video games, though you might see them. So basically, this would be one of those third-party assessments. You could make that call if you want. Other examples would be even like higher level security specific ones that I don't include on the slide here. But Qualtrics, for example, is ISO 27001 certified. That relates to privacy and security standards. If you're seeing those kinds of things, then you are within your right to say, you know what, this meets the audit requirement. We have designated some other company to do this. So hopefully that provides you with a little more flexibility in making choices. As I said, I would still recommend send the DPA first and use this as an option if you feel like the website is fairly low risk. Because again, you are giving up some of your potential freedom. If something were to go wrong, all you would have is basically the report that, you know, in writing that says, well, ISO said they were certified, that should be good enough. Or, you know, you can complain to the FTC in the case of COPPA violations, or if you believe they violated the student privacy pledge. So you're giving up a little bit of freedom, but again, just letting you know that that's a choice you can make. And with that said, I'm going to move on, going to change topics, which is, so what does all of this mean for October 1? Because the board rule lists out, here are the things that our section, specifically me as the student privacy auditor, is supposed to check off for all of you. And we did a really comprehensive check this last October, to the point where it would seem a little strange to me, you know, if your policies were good October 1, 2019, if you haven't made any changes, and we've gone over the regulatory and legislative updates, and I want to make clear that there shouldn't be any changes necessary to your data governance plan. There shouldn't be any changes necessary to your annual notice, your director information notice, data collection notice. Because of that, here's what I would propose we do for October 1, which will hopefully be a lot easier for you and also a lot easier for me. So we still do need to reconfirm the identity and contact information of your data manager and information security officer. So we'll want to get that from you, just to make sure that our contact lists are up to date. If you've already been passed off on your annual FERPA notice, director information notice, data collection notice, and data governance plan, unless you update them, so if they're just the same and you've already been checked off, that's going to be good enough. I don't need to check something that I've already checked. Especially, as I already said, because there is not going to be any new requirements for any of those. Metadata Dictionary I already talked about. We will not be checking for October 1, but once options come online, we will provide guidance and training with the expectation that you will get the information in there that is required, and then we could check it the following school year. There's some other things we've alluded to, so like your PPRA Utah FERPA policy and notice. You're also required to have a notice regarding disclosures to military recruiters and institutions of higher education. These are not specifically designated to our section to check in board rule. So we're going to take the option that this is something we would like to check. We'd like to help you get it in the right place, but we can't make you. So that's how I imagine the October 1 check will go, is like, I'll ask for this information, but I'm not going to hunt you down, or I guess I don't really hunt anyone down. I'm not going to constantly send emails if you don't give it to me. But if you would like to have another set of eyes look at it, we can provide you with feedback and ideas to make it better, or if there's areas where it's not quite in compliance with the law, we can point those out to you and help those policies look good. So those ones will be very voluntary. So what this means, here are the numbers as of the beginning of this month. I'm done tracking down people who we weren't able to get everything this last October. And honestly, most LEAs, I think this will mean that you won't have as challenging of an October 1. Hopefully also the state auditor isn't going to conduct a similar audit at exactly the same time. We have little control over such things. I know that made it challenging to essentially have two different people asking for similar information. But everyone, as I said, we're going to want to know who the data manager is, the information security officer. If you've already been passed off on the next 4 items, so the annual notice, the directory information notice, collection notice, governance plan, unless you have made changes, we're just going to say that that one is still a valid, it's still a pass, and we won't have to do anything too difficult to get that signed off again. But for those that still haven't completed it, hopefully I can work with you a little more this summer and leading up to October 1 so that those can be 100% compliant. Our goal really is we just want to help you get across the finish line with all of these. These are documents, these are policies and notices that federal and state law says you have to have. And we just want to make sure that it has all of the things that state law and federal law says need to be in there. So hopefully this means for a lot of you a much calmer October 1 check because we've already got it all down. So that's what I'm hoping it'll be. And with that said, I'm going to move on to a totally different topic, which is school safety. This was one that last year, so we met in person and we got feedback, one, that we should do this kind of spring training, but also topics that were of interest to LEAs, and school safety was a major one. This is not surprising, as a lot of new bills coming out of the legislature have school safety dynamics to them. And so I'm going to be very comprehensive here and talk about the entire data life cycle, from collecting information to disclosing information. But I want to be a little interactive real quick because we are doing a lot of talking at you, and we can utilize the chat function maybe a little bit. But pre-test here just to see how well you know this information. So I'll ask the question and give you a moment to just throw your answer out into the chat. So number 1, if a teacher observes a student incident but does not record it, that information is protected and may not be shared. So you observe something happens, maybe there's a fight, something like that. It isn't written down. Is that information protected? So if you think it's protected, say true in the chat. If you think it's not, say false. I'm seeing lots of falses. And we'll get to the answers in just a moment. 2, health records maintained by the school nurse psychiatrist are considered to be education records. I think that's true. Those are education records. If you think it's false, say false. Getting a little more mixed response here. Some true, some false. Okay, number 3. Schools in Utah may share information with Juvenile Justice Services, or JJS, but in other states, the rules are different. Seeing so far just a true. No clue. I like that. That's a fine answer. Don't have to necessarily know the answers. I'm going to go over them in just a moment. If a school receives a subpoena for student records, they should always immediately comply with the request. True or false? Got a subpoena in hand, police officers there. Lots of false here. Feeling pretty confident. And Last answer, if a school surveillance camera records a fight between two students, the school is not allowed to share the footage with parents. See a false so far. False. Don't know. I like that. Depends. Depends is always a safe answer. It'll depend on lots of things. But let's go into the the nitty gritty of what are the rules and what do you have to consider with all of these. So as I said, we're going to discuss. We're going to go over technologies that we're seeing schools use that collect school safety data and privacy considerations you should have before collecting. And then also we're going to talk about some common recipients of school safety data and what guardrails need to be put in place before disclosing. So we're seeing lots of different surveillance technologies going into schools. We are aware that email or social media monitoring, companies like Bark, GoGuardian, are incredibly common right now. Security cameras are another one that have been around for a very long time. What we're seeing is some newer ones involving facial recognition. So that's much newer. Security cameras have been in schools for decades to some degree. And then also surveys, right, where you're collecting information from students, some of which might be personal, some of which might relate to school safety kind of information. So before you collect, here are the questions I would recommend you need to ask. And the first question is this an education record? If it's an education record, it's protected by FERPA. FERPA allows, and Whitney alluded to this earlier, something called a law enforcement record as well. Or could it be neither? So some considerations regarding those. And I'll go into those in more detail. So this is the high level list of the questions, and then I'll go into what each of them mean. Is it a necessary or an optional collection? This is something that is stipulated in Utah law. How will parents be allowed to exercise their rights regarding any of these records that you're creating? So will they be able to inspect and review those records? Will they be able to seek to amend the records or seek record expungement, for example? Who are you going to share it with, and how will it be permitted under FERPA? And how long will the records be retained? I think those are 5 really good questions to ask yourselves before you start collecting any information related to school safety. So let's go into each of these one by one. So education record, hopefully you're aware. FERPA protects education records, which means records that directly relate to a student and are maintained by the school. It does not cover things that aren't maintained by the school. So an observation, you might remember this from the pre-test, if something is observed but there's no record, that information is not generally going to be protected, at least not by FERPA. FERPA protects records. If you just see something and it's not recorded, there's no record, FERPA doesn't apply. FERPA also excludes personal notes when they are used exclusively as a memory aid and not being shared among others. Teachers might take these kinds of notes. I think school counselors as well, if they're just jotting notes down to help them remember something. It's not going into any official file. It's not being shared. Those are not covered by FERPA. And one, again, that we want you to be very much aware of are what FERPA calls law enforcement records. These are records created and maintained by the school's law enforcement unit for a law enforcement purpose. Health records sometimes come up in this, and we hear schools say, all those records are protected by HIPAA because they have to do with health. This generally, in a K through 12 setting, is not going to be the case. HIPAA actually, in their definition of protected health information, excludes records protected by FERPA. So basically, if it directly relates to a student, even if it has to do with like their health, and that could include mental health, which sometimes comes up in school safety conversations. In general, that's not going to be covered by HIPAA. It's going to be covered by FERPA, which is good because we're talking a lot about FERPA. You're learning the rules of FERPA and not HIPAA. However, I would say if you are working with, let's say, a threat assessment team that is multidisciplinary, that might bring in student health records from a psychiatrist or someone else from the healthcare world, those ones might be protected by HIPAA, and so that's going to require some conversation. They might not be able to share information with you, even though you might want them to. Actually, I've been in a lot of meetings that have involved the Department of Substance Abuse and Mental Health and the Department of Public Safety regarding threat assessment teams and information sharing. And they have their set of rules, we have our set of rules. We just wanted you to be aware that for the most part, most of the records that you have that directly relate to a student that you're maintaining are going to be covered by FERPA. You don't need to probably worry too much about the HIPAA side of things. Now, let's talk about law enforcement units and in detail what this means. FERPA has this provision largely to make it easier for you to be able to share information with law enforcement that specifically has like a lot of law enforcement purpose behind it. So the first requirement is the district would have to designate a law enforcement unit. This can be any individual, office, department, division, component of a school that is officially authorized and designated. I would think this means you need a policy. You need somewhere official that says, this is our law enforcement unit. They have to be designated to do one of two things: to enforce local, state, or federal law, or to make referrals to law enforcement. So this is why with that one House bill we were talking about with the school threats, if you know that you have a legal requirement to refer something to law enforcement, you should have your law enforcement unit be the one that handles that. There's not a clear FERPA exception for education records to share with law enforcement unless they have a subpoena or there's an imminent emergency. FERPA designed this knowing that there are going to be cases where you do need to share with law enforcement, so it needs to follow this kind of separate set of rules and be designated separately. The law enforcement unit could also be the unit that is designated to maintain the physical security and safety of the school or LEA. Now, in practice, it could be, we are aware that some larger school districts will have a district police unit where you have your own police. It might be the school resource officer. It could be the vice principal at the school. It could be any school employee. What's worth noting is that these individuals then might end up having their feet in two places. In some of the records they create could be law enforcement unit records, and some could be school official, and so they would be education records. So the Department of Education recommends that if it, let's say it is a vice principal or another school employee, or even an SRO, because an SRO could be a school official in some cases and law enforcement unit in others, that, I mean, it's kind of an abstract distinction between the records, but try and keep them physically separate then. Even though they might create records that say the same thing, making it clear that this is the law enforcement unit record. This one shouldn't be used for school discipline, but it can be shared with law enforcement. This one is the education record. We can use it for school discipline, but we can't share it outside of that. Any kind of separation, and I think also training of this individual to let them know, hey, when you're acting in this way, you are a school official. You have to fall under the general FERPA rules. In these cases, you're a law enforcement unit. You have a separate set of rules. That would, anything you can do to help make that distinction clear would be very valuable. So what does it take for it to be considered a law enforcement unit record and not an education record? A lot of it really has to do just with purpose. So it must be created by the law enforcement unit and maintained by the law enforcement unit. If you haven't designated a law enforcement unit, you don't have law enforcement unit records. If you have a law enforcement unit, but like a teacher creates it, it's not being created by the law enforcement unit. It's an education record. And it has to be created and maintained by the law enforcement unit for a law enforcement purpose. If you start using it for a non-law enforcement purpose, say you use it for just kind of school discipline to decide if a student should be suspended, At that point, it is now an education record. If it is relating to anything outside of law enforcement, it can't be a law enforcement record. This is why, again, going back to the school threat and hoax threat bill, those ones, it seems like the bill is really focused on law enforcement purposes, law enforcement referrals, misdemeanors, those sorts of things. That's why we recommend that any records that are kept in regard to that part of it be law enforcement unit records. Now, the school is still within their right to create a disciplinary record about the incident that will cover very similar information, but you've got to keep the two records separate. Because if you start using them for different purposes, it's no longer clearly a law enforcement unit record, and you could be hit with a FERPA violation potentially. Hopefully that makes it clear. It's a very kind of abstract notion, I think, because it has a lot to do with the purpose of the record and a little bit to do with who maintains it. Let's move into what Utah law talks about, which is the next question. Is the information we're collecting going to be considered necessary or optional? Now, Utah law, and this is in the student data collection notice that most of you have, requires you to designate information you collect as either necessary or optional. The necessary list is very large, and a lot of it relates to school discipline and potentially a little to law enforcement purposes and things like that. This is information you're allowed to collect without parental consent, and it explicitly includes disciplinary records. So you may create a disciplinary record. Excuse me, I probably should have had a drink of water. My throat is getting a little dry. You can create a disciplinary record or collect information related to a disciplinary record without parental consent. Juvenile delinquency records, data collected as part of your suicide prevention, intervention, or postvention program. Information required as part of your SIPA required monitoring, because basically if a federal law or state law requires you to collect it, it is considered necessary, unless it is explicitly listed as optional. Or information required for the school to receive from law enforcement as part of state code. Those would all be necessary, so it's not super restrictive. There are a couple you should be aware of that will be considered optional though. So one would be biometric identifiers. This would include if you were considering doing any kind of facial recognition technology in your schools, you would only be able to collect that information with parental consent. Also, information that is protected under the Protection of People Rights Amendment in Utah FERPA. So I'm going to call that protected survey information, even though you might be collecting it using a different tool, not necessarily a survey, it could be an evaluation or other type of assessment. So let's talk really quick about biometric identifiers, because this is explicitly defined in the law. We get asked sometimes, hey, is a student's height a biometric identifier? Is their weight, is a writing sample considered biometric? And the law lists only 4 things specifically. Retina or iris scan, fingerprints, human biological sample for scientific testing or screening. This is most likely going to be a DNA sample. And the scan of hand or face geometry. So this is, again, mostly going to be your facial recognition, although I assume like a handprint would also qualify. Now, the law also states it doesn't matter how this information is collected, converted, stored, or shared. If you are collecting this information to identify a student, then you would have to get parental consent first. And we do have a biometric identifier collection form or a template on our website that you can use if this is a direction you want to go. But I just wanted you all to be aware that it's just this list. If you were going to collect these from students, it's a very small list. It's not anything that relates to their biology, but only some specific things. And also the storage format, how you convert it, like facial recognition, they say it doesn't actually collect your face. It collects a bunch of numbers about your face. The law says that regardless phrase makes it very broad. Anything that would be considered facial recognition would need to be restricted. So what would the notice and consent need to look like? So prior to your collecting a biometric identifier, the notice would need to describe the information, which identifier you're going to collect. So you need to clearly say, we are collecting fingerprints. We are collecting, facial geometry. The purpose of the collection would need to be explained, why you're doing it, and how you will use and store the information. If all that information is your notice and a parent opts in to the collection, then you can start collecting it. Pretty straightforward. The protected survey information, this might come up. Some of the categories more likely than others. So this is PPRA Utah FERPA. You might have seen, Greg and I created a new video that goes into a lot of the PPRA rules in more detail when we were down at Southern Utah University. We throw in a lot of Shakespeare references, or at least one or two, because I see this list is basically, how Shakespeare wrote plays. There's lots of political affiliations, characters with mental or psychological problems, lots of illegal, self-incriminating, demeaning behavior, all sorts of things like that. So that's our way of maybe having a little bit of fun with it. But certainly, if you are going to collect mental or psychological problems, try and understand those from students. Issues D there obviously comes up, I would think, with school safety, illegal, antisocial, self-incriminating, demeaning behavior. You're going to need to follow the rules of PPRA and Utah FERPA. And that was one of the other bills that Whitney talked about. So one that they just addressed this up front, where it's like, this mental health screener is completely optional. Schools don't even have to do it if they don't want to. And if you are going to do it, you have to do it with parental consent that follows these rules. So that was very nice of the legislature to recognize that up front. So specifically what the law says is prior to any, it could be a psychological or psychiatric examination, test, or treatment, or any survey, analysis, or evaluation that has the evident intended effect of having the student reveal any of that protected information about themselves or a family member. And whether it's personally identifiable or not, it doesn't matter. You can't ask these questions of a student, even if you don't have them put their name at the top of the survey. It's that evident intended effect standard. So if you're clearly trying to get them to give you this information, you have to provide them with that 2 weeks notice, and a parent would have to opt the student in. So some exceptions relate to cases where it isn't the evident intended effect. If the student is talking about, if the teacher is talking about politics or Shakespeare, and the student spontaneously raises their hand and shares information, that wasn't your evident intended effect. You didn't intend for them to share personal information. Students can share what they want. The notice and opt-in requirement in Utah law very explicitly only applies to districts and charters. It does not mention if the state is administering it. So that's a little bit of a gray area at the very least, if it's a USBE administered survey, for example. So I'm just putting that there because the law doesn't explicitly require us to get an opt-in. The law does have a large exception regarding suicide prevention, intervention, or postvention, where it would not need to be an opt-in if we're doing it under the guise of one of those official suicide prevention programs. And there's also a provision related to if you believe the student is at risk of harm to self or others, then you can collect information if you believe it will help you assess the situation better or make a referral to the proper authorities. And even then you need to only get the minimum amount of information necessary. That if, for example, if I go back to the list, I don't know, they're legally recognized privileged and analogous relationships such as those with lawyers. Probably, if it doesn't seem relevant, you shouldn't be asking about it, even though you've got a little bit of leeway there. Some of the cases then will be notice and opt out. So where you tell parents, hey, we're going to do this, and you can opt out of it. And those are going to reflect some of the ones that are not clear in the law. So again, the Utah FERPA law only clearly applies to districts and charters. It would not apply to USBE. So if it is a state administration, we'd still have to provide notice and the opportunity to opt out. It wouldn't necessarily have to be an opt-in. And again, if it's part of a suicide prevention, intervention, or postvention program, it would not necessarily have to be an opt-in. You could say, we're going to give this survey, and if you don't want us to, opt out, because that is clearly an exception within Utah FERPA. What does the notice have to look like? It must explain how a parent can inspect and review the materials or instruments that are going to be used in the case of a survey. It should include the URL of where they can see the survey. And it should also explain to them that they have a reasonable opportunity to obtain other information. So what records are you going to examine? The means by which the records will be examined or requested. How are you going to get the information? Why are you getting the information? Who is going to have access to the information? And how can a parent go about being able to review the information, examine the information after you've collected it? You don't have to explicitly explain all of that in detail in the notice. You could just simply say that, parent, you have the right to get this information by contacting the school principal, or it could be something like that. So this is transferring really well into parent rights regarding school safety information. So this is again going to come back to the question of education record, law enforcement record. Parents do not have rights toward law enforcement records. And that might sound like, ooh, that's a little concerning. But again, and from speaking a lot with Department of Public Safety, there might be some very good reasons for this. You wouldn't want to tip off an ongoing investigation. And so that's another reason why you might want to designate something as a law enforcement record. If it relates to a law enforcement purpose, you don't want law enforcement being interfered with, or like a parent being like, hey, can I see your records? And you say, sure. And you hand them something that says, your child is being investigated for drug trafficking things. And then suddenly they, head down to Mexico and you never see them again. Hopefully nothing quite that extreme. But if it's an education record, parents will have a right to inspect and review those records. So you need to be really clear with any kind of school safety record you're doing. Is this an education record? Is a parent going to be allowed to see this? If it's a law enforcement record, the law just says you don't have to allow them to. You could still, right? We talk a lot in those terms where it's like, just here's what you're required to do. You can always do a little bit more. But parents will have a right to inspect and review education records within 45 days of a request. If it's about more than one student, and this is the one that we see a lot with school safety and where it gets complicated. This happens a lot with surveillance. It can happen with paper records as well. We had a really good example where the student brought some inappropriate materials to school, showed it to his classmates. One classmate tipped the administration off, and this was all put in the disciplinary report. Student was suspended, and the parent wanted to see the report, and it was like, well, if they see the report, they're going to know who the student was that tipped us off, and that would be violating that student's privacy. So one option you have, the first one you should do if a parent wants to see a record that has information about more than one student, is ask yourself, can we redact it? If you can redact it and maintain the meaning of the record and maintain privacy for both students, redacting is a good way to go. In this particular case, they felt like, well, since this student showed the inappropriate materials to so few students, the simple fact that it was a student that shared it with us is too much information. Like, they'd be able to figure out who the student was. So we would prefer not to share any information about the fact that a student was the one that tipped us off. So they believed that it was basically impossible to redact and maintain the privacy of both students. If that ends up being the case, then the second option FERPA allows is that you may simply inform the parent of the specific information that relates to their student. So you wouldn't have to black anything out of a record. You wouldn't even have to show them a record. You could say, you know, because of the sensitivity of this, we're only going to inform you of the content of the record. And in this case, they would say, you know, we were made aware that the student had brought inappropriate materials to school, and that's really all you would necessarily need to say in that case. And I already mentioned parents won't necessarily have a right to law enforcement unit records. You'll want to take those really on a case-by-case basis. Again, like I already said, be very sensitive to ongoing law enforcement investigations and not interfering with those. But again, you may have local policies that would allow you to share information off law enforcement records. It doesn't say you can't, it just says parents don't immediately have a right to them. So this goes into surveillance video as well. So if the school has a surveillance video recording of an incident, is it an education record? Well, and I don't have it here in the slide, but it's also worth asking, well, why are we collecting this information? Is it potentially a law enforcement unit record? Have we designated someone, let's say the vice principal, as our law enforcement unit, and they're the one that oversees the surveillance system, and we only use it for law enforcement purposes? We're not using it for any education purpose. That's a way a school could go. If you are not going that way, you'll have to decide, well, is this an education record? And you answer the two questions. Does it directly relate to a student? And the Department of Education has some really good guidance on going through these in more detail than what I'm doing here. But a really good example is like, if they're just a bystander, like if you have a camera pointed at a hallway, class is dismissed, bunch of students are in the hallway, you can see them, maybe even identify them, but it doesn't really directly relate to them. They're just walking through a hallway. Or a better example would be, let's say there's a school fight. And the two students that are fighting, those are going to be the ones that directly relates to the record. Other kids that might be in the background probably doesn't directly relate to them. So you wouldn't consider it an education record for them. And I already talked about the maintaining issue of whether it's the designated law enforcement unit or not. And this is going to be very similar to what I said before, but it's a little trickier because it's video, not paper. But if the video includes more than one student in the incident, again, the fight is a really good example, then it would be an education record for both students. Parents will only have a right to access the records that directly relate to their student. Should you determine that you can reasonably redact the video without changing its meaning, that's what you should do. So you could blur out the face of the other student. If it can't be redacted, then then you cannot charge the parent for the redaction costs unless they want a copy of it. If they wanted a copy of the video, you can charge them for the copy of the video. If you determine it can't be reasonably redacted without changing the meaning, goes through those same rules before. You could provide a description of the incident to the parents. You can inform them of the content of the video. And if even that you don't feel like you could reasonably do, the Department of Ed has said, you know, if you can't redact and you can't inform them in a way that is meaningful, then ultimately you'll have to allow them to have access to unredacted video, and just tell both parents, look, we can't follow the two things above. It would change the meaning too much, so we're just going to let you both see unredacted versions of the video. That seems like, I don't know how often that will end up happening. I would think that one of the two options above, either redaction or informing, should meet the requirements first. But just know that if you feel like you're in a position where neither of those is really going to preserve the meaning of the record, then you do have that as kind of the last option. Okay, parent rights a little bit more. Parents have a right to seek to amend, expunge education records in cases where they believe it is inaccurate, misleading, or otherwise in violation of the student's privacy. Note, this right does not generally exist for substantive decisions such as student grades. I think in a lot of cases with discipline, it may well exist, particularly the expungement part. And again, you just have to give them the right to a fair process. You don't have to actually amend or expunge necessarily on their request. So if you look at their request and say, no, we're not going to do this, you say, no, we're not, but then you have to inform them of their right to an impartial hearing. And if after the hearing, the school still decides that they won't amend or expunge, the parent will have a right to have a statement placed with that record that comments on the contested information. And that statement needs to stay with the record for the entire time that you maintain it. Okay, so we've covered collection of information. We've covered parent rights to information. Let's talk about different groups you might share it with. I know big ones, particularly because of legislation that was passed last year, the 2019 session, relates to threat assessment teams. School resource officers are another big one. We talked about law enforcement, other state agencies such as JJS or DSAMA, so the Department of Substance Abuse and Mental Health, or it could be medical personnel, doctors, psychologists. So in general, information from education records can only be shared with written parental consent. But there are several exceptions to this rule. And some of them really are going to apply a lot to student health and safety. The main ones we're going to see are these exceptions: school official, the health and safety exception, juvenile justice services, the subpoena or court orders exception, caseworkers, and parents. And there are sometimes slightly different rules for parents, particularly if the student is a dependent student. So let me go over all of those. So school official, this is one of the most common ones you use. School officials are individuals employed by the school who have a legitimate educational interest in the student's information. They can also be third parties, people you contract work out to, that may apply a lot in the school safety information. Could be a contractor, an attorney, an SRO. And there's certain requirements that they would have to follow to be a school official. So they have to be performing a service that the school would otherwise use its own employees for. They're under the direct control of the school regarding the maintenance and use of the data shared. And a good way to establish this direct control would be with some sort of written agreement or non-disclosure agreement. And the big thing is they can't redisclose the information they received to other parties. So a good example would be, I'll pick on attorneys. Let's say you work for a law firm and you have an attorney. That attorney works for a law firm, and you consult with them. They can't go and share it with the rest of their law firm because they would not be, the rest of the law firm isn't necessarily providing work that the school would otherwise use its own employees for. So it's supposed to be kind of kept within certain boundaries. SROs are probably a better example of where this gets complicated. An SRO would, if they were a school official, they would, any information they receive as a school official would be have to stay within the school. They couldn't share it with local law enforcement. If it's a law enforcement unit record, then they could share it with law enforcement. So again, hopefully you're seeing that distinction, and also you're seeing why you would want there to be like a physical separation would really help for them to know this is a school official record, this is a law enforcement record. Because some they would be allowed to redisclose, others they would not. And your school also has to designate that party as a school official in the annual notice to parents. If you're just using the Department of Education's template, which I think most schools are, this is probably really vague. It just says something like contractors. You are more than welcome to add specificity, to say, you know, school resource officers, to say our threat assessment team is considered a school official. I think that would be helpful. It's not, I wouldn't say strictly required. But let's talk about threat assessment teams. So members of your threat assessment team likely will be school officials. What this means is that they may access student records if they have a legitimate educational interest in it. So if your threat assessment team involves local law enforcement, involves local mental health professionals, other people who are not school employees, you can say, you know what, you are designated as school officials, you have a legitimate educational interest in this information, let's look at the student's attendance records. Provided that then, so they have the attendance records, They are under your direct control regarding the use and maintenance of those records. And like I said, you could have them sign written agreements, non-disclosure kind of things such as that. You could also think about, like, do they need to take the records home? Or maybe you're just discussing it during a threat assessment team meeting. And the big one is they cannot redisclose that information. They can't go back to their home offices, to local law enforcement and start sharing that. But again, and I'm being very repetitive here, but hopefully it is helpful repetitive. If, let's say, the SRO is designated as your law enforcement unit, any records they create for a law enforcement purpose can be shared with the law enforcement unit, but the education record could not be. Okay, so that's one that hopefully lots of schools, we are aware lots of them are currently using threat assessment teams, and many more are likely going to do so. And we've been working with our school safety team at USBE, incidentally. I know that the law that was passed last year requires USBE to create model policies and documents and stuff, and we're working with them to help get that across to the school safety people as well regarding what are the requirements under FERPA. So hopefully there will be some good materials from them that will meet, like the requirements of, say, CSTAG as well as FERPA. So let's say the threat assessment team figures out that there is definitely a threat. There is an imminent, significant, and articulable threat to a student's safety or the safety of others in the school community. Well, at this point, and incidentally, it doesn't have to be a threat assessment team. Other groups can designate this. So if you determine there is an imminent, significant, and articulable threat to the health and safety of students, and incidentally, this doesn't necessarily need to be a violence threat. If schools were in session right now, there is a major health threat going around. And this exception could be used and has been used in the past. I know, that's the Department of Education had guidance regarding when there was the H1N1 flu. The guidance they immediately posted on COVID-19 related a lot to this, not realizing that schools were all just going to close within the next 2 days. Anyway, so if it meets that significant, articulable, eminent standard, then you may share with any appropriate parties to help mitigate the threat. So that could be local, state, or federal law enforcement, trained medical personnel, public health officers, parents, and other members of the school community. And schools should make that determination on a case-by-case basis, because again, you have to decide, is it significant, is it articulable? Juvenile justice services. And this was in the pretest, you might recall. FERPA allows you to share with juvenile justice services, provided that the disclosure is made prior to the student being adjudicated and in accordance with state law. So if there's no state law, then you can't share with JJS. So the question is, does Utah have a state law that permits sharing? And the answer is yes. And you can find it in 53G 8-11. This one, hopefully some of you are aware of, relates to alternative intervention programs. The idea is we don't want kids going straight to the court system. We want to provide them with some sort of alternative intervention and remediation. So this could be a Class C misdemeanor if they're guilty of that. And go back again to the threat bill. We have that table. This is being recorded, and we'll have the slides available as well, I'm sure. But you'll recall in that that threats against the school bill, some of them were Class C misdemeanors. Others were higher, Class B or Class A. If it's a Class C misdemeanor, then you could refer them to an alternate intervention program. Any other infraction or status offense that happens on school property, or truancy is another one. So if these requirements are met, then you could instead refer them to JJS. And that would be totally fine without parental consent. Subpoena court orders. So let's say someone comes with a subpoena and says, hey, we have this, we need this information. In general, before you share, you need to notify parents of the subpoena along with the timeline for when you'll release the information. So come up with a reasonable timeline, say, maybe a week, depending on what the information is. Say, we're going to release this information within a week if you don't do something to stop it. Some subpoenas will explicitly indicate that the parent should not be notified. And if this is the case, then you should not notify the parents and just comply. So just be aware of that. FERPA lists out some examples of that in more detail, but essentially any subpoena that says, you cannot notify the parents before, then you just comply with that provision. Otherwise, if that's not there, you have to notify the parents and give them a reasonable timeline. Caseworkers, we get asked about this a lot. Particularly, you have your Department of Child and Family Services, lots of different groups under the Department of Human Services, DHS, real alphabet soup here. So sharing is permitted when the student is under the care and protection of a caseworker. It's also permitted in accordance with Utah's Child Abuse Prevention and Treatment Act, or that's also sometimes referred to as CAPTA. In general, this means sharing is permitted with agencies under the Department of Human Services. And this can be tricky because there's a lot of them. So in Utah, here are the ones that are most likely going to be involved with schools. You got your DCFS is a big one. Essentially, do your best to cooperate with DCFS investigations. Our law basically says once DCFS is involved, particularly in a case of educational neglect, they are going to want to know what the student's attendance is. That's the main one you end up seeing. And you should share that with them because the law permits it, and actually they need the information to do their investigation. JJS, we talked about the situations where they can be shared with. SOC, systems of care. Those are the three we were told was most likely. The SAMA was one that we've talked about a little, particularly, so the bill that Whitney talked about, that was the mental health screener, the information will be shared with the SAMA. But no, it won't be with the caseworker exception. It will be done with written parental consent. The law explicitly says you have to have consent before you can share it with them. Okay. And one last question, and this will segue pretty well also into things John's going to talk about. But the end of the data lifecycle is getting rid of the data. And this is a question I think that is a major concern for parents. They're really concerned when it comes to school safety issues of how long you're going to keep this information, how long is it going to follow my student. They're really worried that something that their kid did when they were a dumb third grader is going to prevent their kid from getting that good job in the future. So just to point out that legally, this is going to go back to a lot of our state retention schedules. There is one specifically for student discipline. And again, not everything we've talked about, like law enforcement stuff, isn't necessarily going to be student discipline. John has been working with archives. We need to figure out what some of these things need to say. But I just wanted to say the student discipline one says, you should retain those records until resolution of the issue and then destroy the records. Now, how long is it until the issue is resolved? That's obviously very vague language, provides you with a lot of flexibility for how long you feel that they are relevant, how long it is until they're resolved. And really the thought I want to give, because until we get some more certainty in a lot of these retention schedules, is I would recommend doing your best to balance those interests, knowing that parents are concerned that these records are going to follow a kid and might take opportunities away from him in the future. But on the other hand, you have a responsibility to all the students to keep them safe. So even in determining things like when do we consider that an issue is resolved, try and find that balance, which is to say you probably shouldn't hold on to them indefinitely, but really be thoughtful about how long. Again, it's a silly example, but it's one I give. If someone pulled another student's hair in third grade, is that really relevant when they're in 10th grade? I mean, isn't that issue considered long ago resolved? Would you have gotten law enforcement involved in that issue in the first place? Hopefully not. So just some questions to wrap up. And this is the question we ask. We do this in a lot of different trainings. So just actually, I'm going to skip this just in the interest of time. The answer is, if a police officer because I don't think it'll translate very well in the chat. But a police officer comes to the school saying, hey, I just want to know if a student is in attendance today. There's been some gang violence recently. We just want to ask them some questions. So this is a disclosure to law enforcement. Doesn't appear that they have a subpoena. Can you tell them whether the student is attending school today? And it looks like maybe we got something. We have a no. Well, and this is where we get to the, well, it depends on where you're getting that information from. I think is the answer we want to kind of arrive at. If you're pulling information from an education record, so if you're going to the SIS and looking up, is the student in attendance, then the answer is no. Like, there's no FERPA exception that would immediately allow that. Now, might you know this information without looking the information up in the SIS? And the answer is, well, maybe. Let's say you were to, you're there at the front entrance, you saw the student come in, they're in the building, then you could say, yeah, I saw them, because that's going back to that idea again of it's an observation, right? I'm not looking anything up. I'm not pulling anything from an education record. Furthermore, you could, go on the intercom, right? And just say, hey, so-and-so, could you please come to the front office? Did you reveal anything from an education record in this case? No, you didn't. And we like to throw this one out there just to, again, point out that, it isn't, I'm not trying to necessarily point out loopholes. Maybe a better way to think of it is kind of like a workaround where, there's ways you can be helpful without necessarily violating a student's privacy, without having to go to education records every single time. And in that case, and the follow-up question always is, well, is the student allowed to talk to the police officer without a lawyer there? And it's that's getting far more into the Fifth Amendment. The student doesn't have to talk to the law enforcement officer. They don't have to answer any questions. But you're well within reason of having a good relationship with your local law enforcement and saying, yeah, we'll call them to the front office, and then it's not really covered by FERPA at that point. So let's go over, as I will close up here, the answers to the post-test, pre-test, which is now the post-test, same question. So if a teacher observes a student incident but does not record it, that information is protected and may not be shared. This is going very much to what I just said, and the answer is false. FERPA protects records. If there's no record, it is technically not protected, at least by FERPA. You could have local policies that protect things as you like, but it's not FERPA. Health records maintained by the school nurse, psychiatrist are considered to be education records. In nearly all cases in K through 12, the answer is going to be true. They'll be FERPA records, not HIPAA records. 3, schools in Utah may share information with JJS, but in other states, the rules are different. And this is getting to, again, I revealed more than one. It's going to be true because the JJS exception is entirely dependent on what your state law says. Unless all states have the exact same law regarding JJS disclosures, the answer is going to be true. The school receives a subpoena for student records. They should always immediately comply with the request. Always, I would say that's false. In general, you'll need to notify the parents and give them a time limit before you will comply with the subpoena, and unless the subpoena explicitly says don't contact the parents. And if a school surveillance camera records a fight between 2 students, the school is not allowed to share the footage with the parents. And this one is it depends, but if we're going to say you're not allowed, that's really not true. There's lots of reasons you might be allowed. It might require redaction, for example. And again, there was that last clause where if you can't redact without changing the meaning, and if you can't inform them of the content without greatly changing the meaning, then that's kind of a last option, is allowing them to see unredacted footage. So anyway, just to kind of close up here before passing it over to John, is that there's a lot to consider. I went through it very quickly. Um, as you guys are developing different plans, adopting different technologies, I don't expect you to remember all of this. But hopefully it makes you aware where it's like, oh yeah, there's a thing we need to be aware of. And then reach out to us. We're more than happy to assist. We love providing that kind of technical assistance on how to make sure that you're following all of these different requirements. So with that said, take it away, John.
Greetings. My name is John Lyman, and I am the records manager for USBE. I've been working in conjunction with state archives for the past 6 months to curate all existing education schedules into an organized model based on industry best practices and systems in place in other states. My goal is to guide you through the process of managing Utah's education records. So who is our audience? Hopefully it's you and others that you work with. Some of you just inherited this new record management task and you don't know where to begin. And I'm sure you have some anxiety. That's been kind of the notion that we've received over time. And some of you have been working in records and are looking for ways to streamline your workflow. And that's exactly why this project was started. Some questions you may have are, can I clean out the room with all of those files going back to the dawn of time? How long should we be keeping documents? If we need to keep documents, is there a place to store them? And how should we dispose of documents? And some questions that we hope to tackle in the near future. What are the elements of a student's cumulative folder? We're going to look to define some of those specifics. What student information should I be sending to other schools, and what information should I be receiving? What's up with all of these dead files, and how long should a record take to transfer from school to school? Other states have varying rates. In Wisconsin, it is the next business day. I don't be going to that. So for us to understand where we are and look at where we'd like to go, we got to look at where we came from. We'll be using some pictures from state archives to highlight the importance of preserving documents. Can you imagine the amount of information that has been generated by education entities since the passage of the Free Public School Act by the territorial legislature in 1890? The state has grown exponentially over the century, as has the educational landscape. Imagine what the record management process was like 130 years ago. During that time, LEAs throughout the state have taught children, given grades, and graduated students. Beyond student records, there are also administrative, asset, financial, and personnel records. How would someone in Tooele know if they were creating a record that had already been created in Vernal? Everyone was rightfully working in their own silo. Now that a good portion of records that are created are digital, there are even more questions about how to be an effective record steward. That's my kid. So here we are. You get to decide what type of record you have in your hand, how long you need to hold on to it for, and then you get to do it again with an entirely similar but just different enough record until the whole back room is cleared. So you stare into the abyss of this landing page. You type in some keywords, and if you're lucky, you find something that might fit. But there are 1,300 different types of series, so which one is it? Your anxieties rise. What are you going to do with this? What happens if you get rid of something that you shouldn't have? Oh, why isn't there a simpler process? There should be sound effects. In September, I began to curate what existed into a document that was comprehensive yet concise. We looked at models from around the country and liked what we saw from Wisconsin and Washington. We've been asked interesting questions about cumulative folders, and we're going to continue to work in the background with archives to update titles, definitions, and terminology found in the existing record series. We hope to have a strong cohort of LEA subject matter experts in the different areas of our RAMP model to help us refine the records. So if you have an expert in finance, administration, HR, operations, etc., we would love to have extra eyes in helping us bring all those up to date. So here it is, our RAMP model. RAMP stands for Records, Appraisal, and Management Program. It's a beautiful 50-page document, and as you can see, it's broken up into a few sections. We'll quickly go over a synopsis of what you should expect to find. Here, we're highlighting the benefits of adopting our model, which of course is not mandatory. Hopefully you'll find this glossary of terms that mimics a guide from Washington helpful. I'm still learning a lot of these terms, and there's a lot of different acronyms, and so it's nice to have that glossary. This graphic is available in the RAMP document. It is a guide to reading the model. Here, you'll see the record's name, its corresponding GRS number, which is linked to the archive site. Section C on the right gives a quick glance reference at the disposition and record retention schedule. Section E is the record's description, and if there is a section F, these are the LEA series that exist under the umbrella of this GRS. You may find these documents similar in scope to the above GRS or a document that you may have in your LEA. Our goal in future iterations of this document is to link a model version or example for each one of these series. So if you have a great document that fits, let us know so that we can share it. Section 1 has grouped all of the GRS schedules that fit an administrative management designation. Administration would apply to both the LEA and SEA level. Here, you see listed the types of records you'll find in this section. Board records, committee records, official communications, and reports make up this section. Section 2 has grouped all the GRS schedules that fit an asset management designation. You'll find things like equipment inventories, operations, disaster plan records, and transportation has a section all to itself. We are currently working with the state transportation specialist at USBE to provide an appendix document that breaks out all of the dispositions and records required by both state and federal agencies for transportation. We could see something like this in child nutrition as well, because they too have federal oversight. Section 3 has grouped all the GRS schedules that fit a financial management designation. Child nutrition, as mentioned before in this section, budgets, purchases, payroll, and revenue, including grants, fit under the Section 3 heading. In Section 4, all of your personnel, teacher certification, training, and development records are to be found, as well as anything with misconduct, grievance, or discipline for staff and teachers. Oops. Section 5, finally, it is where we will find what we would traditionally think as education records, and it's only 1/5. The ones dealing with students. In this section, you'll also find records pertaining to schools in general, like specific artifacts, histories, maybe even that old high school playbill. But wait, there's more. Okay. So in addition to our RAMP document for your immediate use, we are including some items that may be of interest to you and the other record stewards that you work with. Should there be a time in the near future where starting a record appraisal and management program would be an effective use of staff time. We're throwing this handy at-a-glance infographic. This is great to have at the front desk, to include in onboarding, or just for decoration. Lastly, I'm going to highlight where this project goes from here. Not only will you leave today with all of these parting gifts, but in the coming weeks and months, expect to receive materials related to cumulative files, in-person support and guidance provided by yours truly. And in conjunction with State Archives, I will create a records manager training aimed at those in the education realm. This will support archive certification requirements. Dr. Archie Almanac will be your guide through the magical world of educational records management. Thank you for joining me on this first chapter. We're excited about the next steps. Please reach out with any comments or questions or suggestions. But before we have questions, we have some answers that we would like to give you. As you can see here, the face of privacy, David Soleil, in his latest video on virtual learning and FERPA. It is on YouTube. It is 7 minutes long and very comprehensive. Some of the questions that we are answering in these FAQs are some of the questions that you may be asking here in just a moment. So just note that those are on the USBE website under the Remote Learning and Student Confidentiality tab. And with that, I believe it'll be time to turn it over to Q&A.
All right. Well, we have a few questions. Why don't you start up there in regards to the mental health screening? Clint asks, will USB be providing a parental consent form?
I'll need to double check the requirements of the law. I know USB has involvement in terms of like, we're supposed to provide a list of approved screeners. I think it's reasonable for us to provide a parental consent form that LEAs can use or modify or do whatever they want with it. I'm just trying to remember if the law says we definitely will be. But I think we can. That seems like an area we can definitely help.
Then Renee asks, if we use our mental health, like the school's mental health contractor to give the screener, does it need to be maintained by the school?
Okay, so something regarding the school official or education records, and maybe I should have made this clear. So it's maintained by the school or the agent of a school. So that's why, like, if you have a lot of different ed tech vendors that are hosting information for you, maybe in the cloud, even though you're not personally maintaining that information, an agent working for you is. So from a FERPA point of view, I would say that, this isn't necessarily, there isn't necessarily a distinction between the mental health contractor maintaining it and the school maintaining it. FERPA would just probably consider it an education record either way. With that said, FERPA doesn't require you to maintain any records. I think in this case, and I'm trying to remember where the bill really ended, but I know Representative Elison kept referring to the school as providing kind of a soft handshake. Which I think his vision was that the SAMA, so the way it would work is you would give the screener and the results would go to Department of Substance Abuse and Mental Health. They would be the ones that would analyze it and would have the results recorded. And that would be fine because you would get parental consent to do that. If they find anything concerning, they'll send it back to the school, and the school can just give that report to the parent and say, similar to, like, it was also compared a lot in legislative session, and Whitney made the same comparison to an eye test, where it's just like, we're not going to give you the glasses, but we had an eye test and here are the results, here you go. So I would say this is a case where the school isn't even required to maintain anything you don't want to, which is certainly another way to approach the mental health screener.
So switching subjects to the student data privacy amendments, Stephen asks, can we provide directory information to online services for students who opt out if we have a DPA or similar contract with them?
Okay, so it all depends on which FERPA exception you're following. If you're following the school official, and that's what the DPA is built assuming that you will be doing the school official, a parent can't opt out of school official disclosures. So if you are using the DPA, a parent can't opt out. At least they don't have that right to do so. If you are only disclosing directory information and you are not following the rules of school official, then you have to honor opt-outs. Which is why, so that bit being in the law, it's minor. I think it'll come in play in maybe a couple of cases. But in general, for most of the ed tech you're gonna be using, it's very likely that you're still gonna have to use the DPA.
Okay, and then Chrissy asked, does SB 166 cover Google extensions that use student email addresses to function?
That's really hard to say as just like, you know, a blanket answer, because different Google extensions are going to do very different things and have their own individual terms of service. And they're going to interact, I think, with Google and Chrome in lots of different ways. The requirements in the law say, you know, if there's a third-party contractor receiving student PII and they're not a general audience kind of thing, which is a vague term, but again, if they're specifically targeting K through 12 education, well, that is who they want. They're in the business of working with. Then certain contract requirements have to be there. Doesn't matter if they're a full-blown website, if they're an extension. So I would say, though, I mean, if it's just student email address, if that's all they're getting, that would be directory information. So you could bypass the DPA and share it in accordance with your directory information policy, knowing, though, that if a parent opted out, that you would either have to get that parent's permission to do that specific disclosure. The other thing with Google extensions is, again, depending on what they do, like they might not even receive any PII. That's the other thing you'd want to check for. Like if they're doing a single sign-on through Google, where like Google has all the information and, you know, Google is the one they log in with, and then Google takes them to the website, and that website, let's say they're just basically like a library. So it's just a way for students to access content. Or I don't know, like if we knew specific extensions, would maybe be a little bit easier. But I use libraries as an example of like, then you can just download stuff. You're not necessarily getting other PII from a student. That's an example of like where you could just do directory information, I guess, or just a student email address. Basically, my overall answer, though, is going to be there's too many different situations to just give one simple answer. Yeah.
Great. Then in regards to the metadata dictionary, and I think you answered this after he typed the question in, but you want to refer to it really quickly.
Not expected to use it or be in compliance at the moment.
Yeah, we won't be checking for this in October.
And that's our fault. And so you can blame us.
So
or we're gonna get there. Let's not. You don't need
in regards to personal notes, Stephen asks, what if the personal note are stored on or in the SIS, but are only available to the person who created the note?
That would still qualify. FERPA is very technology neutral. It doesn't care where you're storing it. It doesn't have to be, you know, written on the back of a napkin. It could be in a formal school system. What it says is it has to be used as a memory aid, and it cannot be shared. It could be shared with like a substitute teacher. So if a substitute teacher came in, it could be shared with them. And so really, I would say that just depends on the capability of your SIS. If it has an area for personal notes that genuinely cannot be accessed by anyone else. I mean, if it's the kind of thing where if, you know, you're the IT director and it's like, oh, let me just enter this like secret password to bypass all of the role-based access controls, and you can get it, then it feels maybe a little less like a personal note, or at least that's more of a gray area. The key is those are the requirements. It needs to be a memory aid and only available to that person, or maybe like a substitute teacher. So in the scenario you're at least asking, I would say the answer is potentially yes. If it meets all those requirements, it doesn't matter where it is.
And that's my favorite thing about personal note as a former teacher, is I got to share personal things with substitutes that I felt like they were needing to know to understand my class.
Yeah.
In regards to HIPAA, you stated something about HIPAA generally like schools don't need to generally follow HIPAA, and then he stated HIPAA doesn't apply to schools unless the school is charging for medical services. So
Yeah, that's far more, you see that more in a higher ed context, where like if you have a school clinic kind of thing, that really complicates it. The Department of Education, they partnered with the Department of Health and Human Services a couple of years ago to provide clarification on when a record is covered by FERPA, when it's protected by HIPAA. Most everything always starts with, if you're in K through 12, it's probably not a HIPAA protected record. We might need to look a little bit more. I know like schools getting reimbursed from Medicaid or Medicare, for example. That might complicate things a little, in that you might need to be sharing information with an entity that is supposed to be HIPAA compliant. It's more just to get across the point, though, that like just because a record is about a student's health, or like a school nurse is maintaining the record, it's the FERPA rules, not the HIPAA rules.
and then
If you have a situation that you think it's a little complicated, we can look into it and let you know in more detail. I just wanted to just get that out in general, that health records, if they're maintained by the school, particularly in K through 12, are almost all of the time going to be protected by FERPA and just be FERPA rules.
so the last question that I have, because I haven't to see if there's any questions since we started this, and you were talking about video surveillance and keeping records and redacting and all those things. So in relation to that, Troy asked, can we maintain multiple copies, the original, student 1 redacted, student 2 redacted, multiple students redacted, etc.? And where would each record be maintained if multiple copies?
FERPA puts no requirements on you to maintain anything. Like if you just wanted to just stop having records in general, FERPA doesn't care. So the answer is yes, you can. You could do it that way. That feels maybe a little needlessly proactive, although you know your local population. If you know that anytime you create a record on more than one student, parents are definitely going to be coming in, so you might as well just redact it to begin with. I would say in general, like until you have the request, redaction can be time consuming, and like, is that really what you want to be spending your time on, is just proactively redacting records that you don't know if anyone's going to even ask to look for? With that said, like, I mean, where you would actually maintain those records would be entirely up to you. I think it only becomes an issue, again, if it's a law enforcement unit record. So you're creating it and maintaining it and using it for a law enforcement purpose, as opposed to a school discipline purpose. I would recommend, again, that law enforcement records are kept physically separate from education records, assuming that these are all just multiple copies of education records. Like, it would depend on, like, is it a paper record? Is it a video record? Those are going to obviously raise complications. If we're just going to say, though, like if there was a fight and you had paper records, you could have one version of the record that pertained only to student A and that was essentially redacted, and keep that in student A's folder. And then the record for student B could only pertain to student B, and that would be only kept in that folder. That really just depends on how you want to handle records management. And like I said, it depends really on how much you think it's worth putting in proactive effort to create multiple copies of records on the off chance that parents are going to request access to it. But like I said, you know your communities better. You know if that is going to be the case. If you know for sure parents are going to constantly come in and ask you for these things, then maybe being proactive isn't a bad idea.
Okay, and the last one's for John. So Platt asks, is the RAMP document just like a model retention schedule of sorts?
Yeah, that's exactly what it is. I've actually got it up, Greg, if you want to turn off. So it Hopefully you guys can see this. So here's an example, section 3, financial management. Everything that you see here as far as the title, the GRS, the retention, the disposition, these are all pulled straight from Archives' website. All of these GRS apply to all of the governmental agencies. However, these are the ones that exist under this umbrella at different LEAs. So Alpine has a balance sheet report that is this, and if this is something similar to what you have, then you can use this as a guide. All of these then are filed under these GRS, and it's structured by these 5 different tiers, and then we go, we order it by GRS sequence, and then these are all alphabetized. And your LEA may have something that fits under here that I didn't get. That might mean that it's duplicated elsewhere. Like yearbooks, we had, I don't know, maybe 15 different series, but as you can tell, if you've got something for purchasing and you need to do something with a vendor list, I mean, everything that you should have a record for should be in this document. And if you don't have that record, then this document can tell you that you'll need this document. I can see over here on the left that where can we get it? As soon as I run it through another ADA compliance test, we should be able to hopefully get it up on the USBE website by the end of the week. I do think that we will be packaging all of this in an email, including the video. So I will have this PDF, this interactable PDF, plus the infographic attached to that for immediate use of everybody that will receive that email. And then you guys should just be able to hand it off to any of your record stewards at your LEA, and they should be able to use this as a resource to organize all of the stuff that they have and connect with Rebecca Shaw at Archives, but also they have a new specialist named Avalon Snell that I'm sure we'll all be getting to know here within the next couple of months as well.
We gave you a lot of information all at once. We want you to know that we're here. We're responsive. We know that we're going through a lot right now, both in education, our work, and our own personal lives. So please, if you have any follow-up questions about what we presented or anything that you need help with, reach out to us. We're at privacy@schools.utah.gov, or you can give me a call at 801-538-7523. That's my phone number, and it's forwarding to my cell phone. So we are here to help, and we sure appreciate your time, and we hope you have a very lovely day.